Yes, good evening everyone. So today we'll be discussing the Insolvency and Bankruptcy Code and its relation to the real estate sector, and we'll be looking at, most importantly, at two new concepts which are hotly in discussions in the present time, that is reverse CIRP and project-wise CIRP. So now, starting with uh, the real estate sector. So right to own a property or right to own a home is a dream for everyone. And as we all know, there's Article 300A, which has been there in the Constitution of India. Earlier, right to own a property was a fundamental right, and then later on, it was made into a constitutional right. But nonetheless, the importance attached to owning a property does not become has not become any less. So, but when we see the real estate sector in the present times, so there are big developers which have come into the market and they have some sort, they have established some sort of practices through which they have been able to take over the market and establish their big businesses. And basically, they have turned this owning a home dream into a totally a business and a financial decision. So the problem has arisen in the past few years when this real estate sector has got a very big boom in the market, and there have been very less options available to the buyers to remedy the losses which they are suffering due to the delayed possession and majorly due to the delayed possession and the compensation aspect when such possession is delayed by on the end of the builder. So the buyers were vulnerable in the market, and to resolve these issues in 2016 itself, when the Insolvency and Bankruptcy Code also came into force in 2016, the Real Estate Regulation Act also came into force to remedy the problems which were being faced by the home buyers. And unless and until the uh, so the Real Estate Act was proving to be sufficient in resolving the problems faced by the home buyers, unless when the issues started cropping up when these real estate developers and promoters, these big real estate companies uh, went insolvent. So what do you do when a real estate developer goes insolvent? Where do the home buyers stand is now the major issue, because initially in the Insolvency and Bankruptcy Code, they do not find any place. Therefore, this issue, which came up in the year 2018, where does a home buyer stand when the real estate developer goes insolvent? So this issue, we are going to look into this issue, and for that, we are going to see how the Indian judiciary has proposed new concepts to resolve these issues. Then, what is the fate of the real estate projects in the present times? Are they to be addressed under the Insolvency and Bankruptcy Code, or is the Real Estate Act is the most appropriate remedy for the home buyers as well as for the benefit of the real estate developers? So, when we move forward and we see how these home buyers were born under the IBC regime, so the most important case law for that would be the case of Chitra Sharma versus Union of India. So this is basically the case of JP Infratech Limited. When this real estate developer went insolvent, so a bunch of petitions came to the Honorable Supreme Court of India, and the title case was Chitra Sharma versus Union of India, and this particular case law became a turning point for the home buyers' rights and the jurisprudence of the IBC. So, when this case was pending before the Honorable Apex Court, the Apex Court directed the Government of India to constitute an insolvency law committee in the year 2018, and that committee took over the task of analyzing the rights of the home buyers and what all remedies can be there for a home buyer when a real estate developer goes insolvent. So that Insolvency Law Committee 2018, while this particular case was pending, they suggested that the home buyers should be included under the ambit of financial creditor under the IBC. And why? Because the money which has been invested by a home buyer in a real estate project, that money is used by the developer to further construct the project, to further invite more allottees into the project. So that money is having a commercial effect of borrowing for a developer. So by propounding this analogy, the Insolvency Law Committee 2018 recommended that the home buyers should be seen under the ambit of financial creditors under the IBC, and they should be given all the rights which are there for the financial creditors, such as a right to seat and vote in the Committee of Creditors meeting. However, there were some conditions which were there. For example, in Section 7 of the IBC, we can see that the, there there's a minimum prescribed limit that whether there should be minimum 100 home buyers or 10% of the total home buyers which are required to initiate an action under Section 7 of the IBC against a real estate developer. So that is there, but ultimately these home buyers were given the status of financial creditors in the IBC. Now, this Insolvency Law Committee of 2018 has also noted a point that even the Bankruptcy Law Reforms Committee, through which the IBC came into being, that committee also did not note the impact of real estate sector on the IBC and whether the IBC will become relevant in the real estate sector, because one reason may be because they knew that there is a separate real estate act which for the redressal of the home buyers issues. So that is there, and this particular case brought into the effect the Insolvency and Bankruptcy Amendment Act of 2018, which came into force on 6th of June 2018. And with that Amendment Act of 2018, the definition of financial creditors was amended, and the home buyers were included in that definition. They were given rights under Section 7 of the IBC as well. So, moving forward, then once the home buyers are now included in the ambit of financial creditors under the IBC, so it was bound to happen that there will be now clashes between the two acts. One is the IBC, another is the Real Estate Act. So to resolve that clash, we moved to see the Pioneer Urban Infrastructure case, wherein the major core issue discussed before the Supreme Court was the clash between the IBC and RERA, and in the event of their overlapping jurisdiction, which legislation should prevail over the other. So the Supreme Court in Pioneer Urban Infrastructure case specifically noted that these two legislations are to be read in harmony. Now, by that, the Supreme Court did not mean that the a home buyer has the option to initiate action under IBC as well as under RERA. The Supreme Court clarified that the home buyer has an option either to initiate action under the RERA Act or under the IBC, but for initiation of action under IBC, as we previously discussed, the conditions, the prerequisites of Section 7 has to be met. So, in that manner, the Supreme Court clarified that these two legislations are to be read in harmony, and they are not in derogation of each other but in addition to each other. Moreover, when a situation is there that there is a clash of RERA and IBC with each other, then the Supreme Court clarified it is the Insolvency and Bankruptcy Code which shall prevail over the RERA, because see the objectives of Insolvency and Bankruptcy Code and when compared to the Real Estate Act, obviously there are more stakeholders involved under the IBC, and an IBC action is uh, that is the reason why the IBC proceeding should be given more weightage than a RERA proceedings. That is why once the IBC proceedings are initiated and a moratorium period is under Section 14 is begin with, the RERA proceedings are to be stayed. So this was the judgment of the Supreme Court in Pioneer Urban case, which resolved the issue of the clash between IBC and RERA. However, the story does not stop here. The issue is not only whether the RERA should prevail or IBC should prevail. The more issues started cropping up once the more and more cases reaching to the NCLTs, NCLATs, and the Supreme Court, and it all came down to become a one huge real estate puzzle. And for that, we must refer to the case of Winter Hills 77 Buyers Association, and this is the NCLAT judgment. In this particular case, so the Honorable NCLAT has framed three major issues, or in other words, three major challenges which were being faced in IBC, and when coupled with the problems of the real estate sector. Whenever a real estate company comes under the ambit of IBC, what are the challenges that are being faced by in resolution of these companies? So there were three major issues which were highlighted by NCLAT in this judgment. One issue is that the home buyers, though they were given the status of financial creditors, and yes, when they are given the status of financial creditors, they are to be included in the Committee of Creditors. They are to be given the right to vote and their right to seat in the Committee of Creditors, and obviously they'll be having a say to choose the appropriate resolution plan or how to resolve the company. So, first issue with regard to this was uh, highlighted that the home buyers is not equipped with the technical knowledge, or let's say in simple terms, the appropriate knowledge to resolve a particular entity. See, usually we see the composition of the Committee of Creditors is the financial creditors, and usually the financial creditors are the banks and the financial institutions. These banks and financial institutions have in their team the experts who have the appropriate knowledge how to resolve an entity, what all aspects are to be looked into. But a simple home buyer who has only invested his money to, you know, to with a dream of owning a home and led a peaceful life thereafter, he is not expected to be, and he does not have the appropriate knowledge to resolve a particular entity. So this was the one major issue in the real estate insolvency cases when the action is initiated only by the home buyers and there are no other financial creditors. So the COC is now constituting of only the home buyers, and these home buyers are not having the appropriate knowledge to resolve the entity. They are not being able to take the decisions in the Committee of Creditors meetings. So the resolution professional is left alone, and he cannot make decisions on his own because the court does not give him that power. So this was the first issue which was highlighted by the NCLAT, and the second issue which the NCLAT explains as a tricky situation, that when the resolution plan is approved by the Committee of Creditors, now the successful resolution applicant is looking to take over the assets of the insolvent company. Now, in the real estate insolvency cases, the assets of the company are the residential units or the flats which are there. So, a successful resolution applicant cannot possibly take the possession of those residential units or flats, because those particular residential units or flats are bound to be transferred to home buyers because they have invested in those flats and residential units. So then there is this problem that who should take over the assets, whether it should be home buyers or it should be the successful resolution applicant. Then the third issue which the NCLAT has highlighted, that usually we have seen that there are a general practice in the insolvency cases that the creditors are forced to take haircuts. Now, when it comes to a home buyer, he cannot be expected to take a haircut because the money he has invested is for a particular home and he needs that home as it was promised to him. So the situation of haircuts with the home buyers becomes again a questionable thing because a home buyer is not in the position to take any haircut. So these three problems were highlighted in the Winter Hills Association case by the NCLAT, and then the NCLAT moved forward to resolve these issues, and for doing so, the NCLAT propounded new two concepts, which number one is reverse CIRP and second is project wise CIRP. Now we discuss these two concepts one by one. So starting with reverse CIRP. Now reverse CIRP is basically a backdoor entry for the ex management to come forward and become part of the insolvency resolution process, to infuse funds as a financial creditor and uh, complete the project, which is later to be transferred to the home buyers. So basically, so in a situation when a real estate developer goes insolvent, so that particular project is now being stalled because the moratorium is in place. The resolution professional has taken control over the assets of the company, and the ex management has officially been thrown out. So how do you construct the project further and how do you deliver the promised units to the home buyers was the issue. So to resolve this issue, the NCLAT propounding a concept with the name of reverse CIRP, wherein the NCLAT said that okay, let the ex management come into picture, let them infuse the funds and build the project, complete the project, and transfer the project to the allottees, and later on, a resolution plan for the leftover assets can be invited and a successful resolution applicant can be there. But the situation is a bit tricky because when you are inviting ex management to infuse the funds into the project, indirectly that particular ex management is now becoming a new successful resolution applicant without there being vote by the COC meetings. So this is one concept which was propounded by the NCLAT, and as it was also discussed in Chitra Sharma versus Union of India, it was the Supreme Court then denied this concept because the Supreme Court said that it is in direct contravention of Section 29A of the IBC, which says that you cannot ex promoter, ex developer, or ex director cannot come again and take part in the revival proceedings. So however, when we go to the case of Indian Bulls Asset Reconstruction Association versus Ram Kishore Arora case, so in this case the Supreme Court could not uh, explain better what is reverse CIRP, why is it necessary. But however, the Supreme Court has made a very good point, and that good point reflects the temptation that to protect the home buyers, this reverse CIRP has to be there. The Supreme Court particularly noted that the efforts are being made for the infusion of funds with the active assistance of ex management. but without creating any additional right in the ex management. So reverse CARP concept is itself is in confusion because the courts are not very clear on this instance that you are inviting ex management to infuse funds. Later on, you are also inviting another resolution applicant. What is the role of the ex management exactly, and what is the role of the successful resolution applicant exactly? Is a bit confused, a bit conflicted, but the need of the hour is the protection of the home buyers' rights, and to protect those rights and to uh, fulfill the commitment given by the real estate developer to such home buyers. This reverse EARP concept has been followed, but in rare cases. However, when we look at the second concept propounded by the NCLAT in the Winter Hills Association case, it is the project by CARP. Now, project by CARP is a very smart idea because if you see the thinking behind project by CARP is very straightforward. So, a real estate developer is having multiple projects. Let's say uh, a particular real estate developer is developing projects in the area of Haryana as well as Punjab as well as Delhi as well as Noida as well as uh, let's take any other state for that matter. So a particular single developer is running multiple projects and those projects are independently registered with the RERA authority. So if and so one project goes insolvent, there is a case of insolvency initiated. Let's say in Gurugram, the home buyers get together and initiate an insolvency resolution proceedings against the real estate developer. So the idea behind Project by CARP is that if a single project goes insolvent, you don't go and you stall the other multiple projects that are going on. There has been a problem in one project, focus on that one project and resolve that particular project. You can take that single project and invite applications from the resolution applicants to resolve that particular single real estate project rather than you for one project you stall the other 10 projects and now you are inviting the applications, you are collating claims of the creditors who are involved in those total 11 projects. This will again take a lot of time, a lot of funds, and then ultimately the result will be that it may not get resolved and the company is ultimately being pushed into liquidation and then all these projects are being liquidated, hampering the rights of the home buyers as well. Therefore, project wise CARP is a very smart idea that if a single project goes insolvent, you resolve that particular single project and you leave all the other projects and give the developer full autonomy on those projects to develop those projects and to carry out all the necessary actions without being affected by the one insolvent project. So, in this manner, there is a uh, there is fairness for the home buyers, and it is the process becomes easy for all the stakeholders. There is not bunch of claims coming it, not the flood of claims coming to the RP. The RP jobs also become easy. So therefore, project wise CARP is a very good uh, step and which should be followed in the real estate cases. And then now we see it was started with the Winter Hills Buyers Association case, and then there have been cases of Anup John versus Nucleus Premium Properties, and then Ambika Prasad Sharma versus Horizon Built on, then Whispering Tower versus Abhay Narayan. So there are many instances where this project by CARP has been followed, and the results have been very good in the as reflected in these cases as well. However, there is one case of Mr. N. Kumar, which was there in the NCLAT Chennai. In this case, the NCLAT Chennai has distinguished their stance from the stance of the Enclad Delhi in the Winters Hills Buyers Association case, and the Enclad Chennai has somewhat confused the two concepts. So, in this N Kumar case, interestingly, Enclad Chennai has said that this particular project by CARP and reverse CARP, as propounded by the Enclad Delhi, they are very peculiar concepts and they can be applied only after analyzing the facts and circumstances of each case. These two concepts cannot be followed as a rule and they can be only applied if the facts and circumstances are such, and therefore they distinguishing their stance, they denied to apply the project by CARP. And furthermore, with the confusion which was created by NCLAT Chennai in this case was that they confused that reverse CARP is like, while they were analyzing the case, they said that in this particular case, reverse CARP is not possible, and hence project by CARP is also not possible. So they somewhat confuse these concepts to go hand in hand. Rather, the intention of the Enclave Delhi and Winter Hills Buyers Association case was not that when there has to be a project by CARP, it is not necessary that the reverse CARP should also be there. So these two concepts are not interlinked. They can be followed separately as well. But Enclave Chennai has somewhat confused this position because from the judgment of the Inclad Chennai, uh, it is easily reflected that the Inclad Chennai is saying that the reverse CARP is sine qua non to the project by CARP. So this confusion has led to some judgments not being very, you know, bent towards the project by CARP. However, there have been many instances where the real estate projects have been resolved project wise and the results have been very good. So now moving forward, now these two concepts are the concepts which are there in the IBC and real estate sector, and these two concepts are being followed, uh, like are being discussed very hotly and also being followed by the NCLTs throughout the nation. Yes, there have been many disagreements between the NCLTs themselves, but again, project by CARP and reverse CARP, both concepts are propounded to resolve the problems of the home buyers. So, having discussed the concepts of reverse CARP and project by CARP, we now move forward to the Amitabh Kant Committee report of 2023. So, this committee was set up by the Ministry of Housing and Urban Affairs. So, this committee was basically was better known as the legacy of stalled real estate projects, and this committee was tasked with the main its main job was to examine the legacy of the stalled real estate projects, and this committee, after collection of the data, has uh, come to note that there are total of 4.12 lakh stalled units in the real estate market, and the main reason for these stored units are the real estate companies financial viability. There are no funds, there is no uh, what do you say there is no infusion from the uh, like there is no credit to run these companies. The banks are not providing them credit, they themselves have not any funds, and that is why the progress of these 4.12 lakh units have been completely stalled. So this committee discussed how this stalled units can be recovered. So while proposing many solutions. The committee was of the view that the lead role in this should be played by the RERA authority and the state government. So, particularly talking about the uh, role of the RERA and state government, this committee has proposed that there should be some sort of rehabilitation scheme, and the committee laid down many points saying that what all steps should be taken by the state government, and what what is the relevant point for us to focus in this committee report is the recommendation of this committee that the Insolvency and Bankruptcy Code should be used as a last resort in the real estate sector. So that is one surprising recommendation given by this committee, and why somewhat conflicting position of the report itself, because the report starts off by appreciating the IBC. So the committee particularly notes that there have been more than 30 cases of real estate sector which have been resolved under the IBC, and later on the committee comes down heavily on the IBC and saying that the IBC is not efficient in resolving the real estate projects. So uh, there is a conflicting opinion as reflected in this report. However, what we are going to focus on that the shortcomings which have been highlighted by the Amitabh Kant committee report, and what all reforms they have proposed. So, firstly, as we were previously discussing, that the project by CARP is a very good initiative and is a very good concept to resolve real estate projects. The Amitabh Kant committee report also supports the idea of project by CARP, and it says that since the registration of the real estate projects is done separately with the RERA authority, the projects can be easily revived on a separate basis. Secondly, what this committee has proposed that the when the real estate project goes insolvent, the resolution professional should be empowered to transfer the ownership and possession to the home buyer during the CIRP is going on, so that the rights of the home buyers are protected at the very initial stage. And also, this committee recommended that the home buyers should be given the option to take over the possession on as is where is basis, and they can pay that much amount. For example, if the structure of the flat is ready and only the interior parts as promised by the developer is not done, so the RP can transfer the possession of that particular flat for on as is where is basis for that particular amount, and thereafter the balance amount which is there for the interiors and other works, that can be carried out, that need not be paid to the RP, and that can be carried out by the home buyer on their personal level. So this was the second reform recommended by the Amitabh Kant committee. Then the third recommendation which the Amitabh Kant committee report has said that once the possession is being transferred during the CIRP, so there should be execution of sale deed as well. But here a tricky situation comes in, because when the RP comes into picture, the management is thrown out of the management is thrown out of power. So when now RP is in control of all the assets of the corporate debtor, so now the question here becomes that who should who would be the relevant person to get the sale deed executed? Is it the RP acting on behalf of the real estate company, or it should be the real estate company? Then fourth recommendation given by the Amitabh Kant committee report was the uh, that it suggested that there should be a fast track, establishment of fast track NCLT benches to resolve the particular real estate cases. So that is always there. The modification in the infrastructure as established under the IBC should be there. And last suggestion of the Amitabh Kant Committee report with respect to the IBC and real estate sector was that they recommended that before a real estate project is uh, being pushed into insolvency, the NCLT should invite comments from the RERA, that whether the RERA authority, where there are technical members present having expertise in the real estate sector, whether they also think that this particular real estate project or company is fit for going through the insolvency resolution proceedings. So this was the last suggestion which was given by the Amitabh Kant Committee report, that what should be done when a real estate project or company comes to the NCLT for insolvency resolution. Now, as far as the stance of the Amitabh Kant Committee report is concerned, when they said that the IBC should be a last resort, what this committee report falls short of is this committee does not highlight the inherent delays in the processes of the state government, and the delays and the flooding of cases in the RERA. So this committee has not discussed these aspects. If there are inherent delays in the process of the state government, so the state government cannot, even if possibly the state governments are in the position to propose a rehabilitation package for these projects, later on there will be issues of corruptions, malpractices. So these issues are like these issues have always been there. So these issues need to be addressed also, that there should be no corruption when real estate sector is one of the like, what do you say, that it is the one of the biggest sector where the infusion of funds is very high. So there are, where there are investments are high, there are more infusion of funds, and so there becomes a chance, very high chance, that there will be malpractices from the end of the governmental bodies as well as the private persons. So that is there. That is something the further committee should look into when discussing the effects of real estate sector and the insolvency bankruptcy code. So now moving forward, when we take into consideration the recommendations made by the Amitabh Kant committee report, so we come towards the amendments which have been proposed by the Insolvency Bankruptcy Board of India through their regulations. So, interestingly, what you all should look into also is the discussion paper released by the IBBI in the month of November 2023, and thereafter, I think there has been one more discussion paper released by the IBBI in the year 2024, which discusses the problems in the real estate sector. And particularly, this discussion paper has somewhat followed the recommendations proposed by the Amitabh Kant Committee report, and it discusses three major uh, changes which were there in the discussion paper and now have been materialized in the month of they were materialized in the month of February 2024 with the amendment to the CIRP regulations. So, firstly, is the separate project accounts. That is Regulation 4D of the CIRP regulations. So, IBBI has amended the regulations to add Regulation 4D, and now there are, when it comes to the resolution of real estate projects, there are separate bank accounts which are being maintained and which can be operated only through the countersign by the resolution professional. So that is something that maintaining of a separate bank account, so that the when you are reviving a project and when the concept of reverse CARP comes into play, so that particular X management is required to infuse funds into this particular bank account, so that there could be, and which is under the direct control of the resolution professional. So the possibility of there being any misuse by the ex management while getting a backdoor entry through the concept of reverse CARP. So this maintaining of separate bank account helps in resolving the issues which may be there in the reverse ARP. Secondly, to promote the project-wise resolution idea, the regulation 36A has been added in the CIRP regulations, where the RP now has the discretion to invite a resolution plan separately for each project. See, when a real estate company goes insolvent, and let's say a real estate company is having 10 projects on their plate, it becomes a very hefty amount for a resolution applicant, for a company who is looking over to, put in a resolution plan and take over the affairs of that company. So the amount becomes very hefty, and the possibility of getting a resolution applicant also becomes very low. Rather, when you are resolving a real estate company project wise, so it becomes easy for the RP to invite um resolution plans project wise, because then there because each single particular project would require less amount of money, and there can be more applications from the resolution applicants. So that is the idea of project by CARP, which is also there, and that is the idea through which this regulation 36A has been added. Then, lastly, they have also added regulation 46A in the liquidation process regulations, whereby the real estate units, the flats, the residential units, are excluded if and so the real estate project or the real estate company is being liquidated. The units which have already been sold and the possession has been transferred to the real estate allottees, they are excluded from the liquidation estate. The liquidator or the resolution professional are are specifically to exclude this residential unit from the resolution, from the when he's preparing the liquidation scheme. So these are the few changes which the IBBI has implemented. Now, I think we have covered almost all the important and major points of the IBC and the real estate sectors, and what all concepts are being followed in the present day times, what are the problems that are being faced. So, reverse ARP, if we are to discuss once again, it is indeed indirect clash with Section 29A of the IBC, because it provides a backdoor entry to a failed promoter. So, and there have been a very conflicting stances of the courts in India. The Supreme Court in Chitra Sharma vs. Union of India particularly denied reverse CARP. Later on, in Indian Bulls Asset Reconstruction Company, they said that okay, reverse ARP has to be there, but it has to be there without creation of any additional right in the ex management. So it is being followed rarely, and personally also the reverse CARP concept should be discouraged, because yes, it is giving a failed management another opportunity, and there is no guarantee that once the management has failed, there is no guarantee that again you give a backdoor entry to that management and again there is a failure. So that in that eventuality there will be more harassment of the home buyers than they have previously suffered. However, project by CARP on the other hand, it is indeed a scalable solution. It must be followed. It is a very uh, it is a very practical solution to the problems which are being faced in the real estate sector, and it is easy for each and every stakeholder involved in the insolvency resolution process, starting from the home buyers themselves to the resolution professional to the resolution applicant to the committee of creditors. For everybody, project by CARP is a very good concept. However, when we are discussing these two concepts, there must be a degree of judicial discretion which has to be there. There can be no, straightforward jacket formula that okay, for reverse EARP there has to be 1, 2, 3, 4, 5 these prerequisites. For project wise EARP there has to be so and so prerequisites. So when exercising the sorry when deciding the factor that whether the project should go project whether the real estate company should go project wise should go undergo project wise CARP, or they should be, you know, uh, the ex management should be given one more opportunity through reverse CARP concept. So appropriate judicial discretion is necessary depending upon the facts and circumstances of each case. And lastly, the Insolvency and Bankruptcy Code, yes, it does not like it was never intended to cover the ambit of the home buyers, but yes, still the IBC has been amended, and yes, it has been amended. Like it has to be very practical when the issues are coming in from the home buyer side. So there are a lot of things which needs to be done in the IBC, but if we see the protection of the home buyer's right, I think the real estate regulation authority is still the most appropriate forum for the home buyers. Why? Because the real estate regulation authority in these, like in the present times, they are also working very diligently. And for that matter, you guys can look into the case of one Messrs. R City Builders. So, yeah, it is a builder in the state of Haryana, and the case is right now going on in the Panchkula Real Estate Regulatory Authority of Haryana. So, in that particular case, when you go to the website and you search this case, you will find when you go through all the regular orders being passed by the RERA authority, you will find that RERA authority itself has taken up the task to conduct forensic audits to, you know, to actually revive the project by the uh, builder himself. So I'll just give you a brief idea. So in this case, initially a bunch of home buyers approached RERA authority seeking refund, and few of them seeking refund and few of them seeking delayed possession. So later on, these complaints were admitted for hearing, and reply and everything was being received. So later on, few allegations were put up that the company has, the builder has committed fraudulent activities, and for that purpose, the forensic audit has to be done. So the RERA authority has ordered forensic audit as well, and they continuously, sought reports from the auditors they have appointed from the management. And later on, in this case itself, this particular builder's case also went to the NCLT. Section 7 petition was filed, though it was later on settled by the builder under Section 12A of the IBC, and the matter was then came back to RERA. The RERA, on continuous occasions, they are asking the builder to complete the project, and I think in 2018 this litigation was initiated, and now it has been 9 years, and since this sorry, it has been 7 years, and this litigation is still going on, and the RERA authority is continuously monitoring the project. The project is being completed phase wise, tower wise, and continuously the RERA authority is asking for reports. The RERA authority is directing the builder to execute the conveyance or sale deeds in favor of the allottees. The allottees are being continuously transferred the possession as soon as the towers are being completed. So when the RERA authority is in itself is very diligent, and the appropriate amount of powers are being given to the RERA authority under the RERA Act itself. So there is very less need for the, NCLT or the IBC route to, follow for the home buyers. So for the home buyers, I think the appropriate remedy lies under the RERA Act. In in rare case where the real estate company or the real estate project is now totally insolvent and there is no chance of revival, it has to go through the CIRP. Then only the home buyers should come to the IBC. Obviously, IBC with all the amendments and everything, the procedure is becoming efficient day by day. So the home buyer needs to decide diligently which route he's to uh, take his which route he needs to take up to resolve his remedy. But still, the IBC and the RERA, they should go hand in hand, and the decisions are to be made accordingly. So I think that's it for today. We have discussed uh, like all the new concepts in the real estate sector, and when it is seen through the eye of the insolvency and bankruptcy regime. So good luck. The case laws which I have mentioned, try and go through those case laws. The Chitra Sharma case law is very important one, and the Amitabh Kant Committee report of 2023 is also again a very important one. And the Winter Hills Buyers Association case, through which these new two concepts are propounded by the NCLAT, is also something you guys must look into to understand better that how this real estate sector is being evolved when in the field of insolvency and bankruptcy law, what is the relevance of the IBC in the real estate sector. So thank you all. We'll see you in the next class. Thank you.